I've got a boom mic,
Okay,
and we can play it back here and see how that comes out.
You're just going to need to keep your voice up, Frank.
Keep my voice up.
Yes, sir.
Up high. Low.
And we are recording there. We are recording here June 8th, 2007. And will you identify yourself for the record, please?
You don't even know me. I can't believe it. I want to kill
I was
you.
going to say, please state your name for the benefit.
Yes, yes. This is like a deposition,
the
sort of.
The unknown lawyer.
The unknown lawyer.
Frank Maloney.
Judge, I don't want to embarrass you, but how old a man are you?
79.
And is it really true that you have been a prosecutor, a defense attorney, and a judge?
That's got to be the most stupid question I've ever asked.
And I would expected you to say that, Judge, but I want to just...
But it's true.
It is true. All right. Well, let's start at the beginning, if you would.
Oh, boy.
Okay. I just want everybody to know just a little bit about your background. Okay, so I'm going to let you give kind of contemporaneous. Tell us what you want us to know about your background up until the point in time you were licensed.
I was born in Massachusetts and went into the Army right out of high school, the end of the war, World War II, and for 18 months. But by the time the 18 months was over, I was at Officer Candidate School, and I was in for another 3 years. Finally get out after getting shot up in Korea, and was sent to the University of Texas from Brooke Army Hospital to teach ROTC. Decided I better get an education, so I went right through undergraduate and law school later.
So when did you get out of law school?
1956.
When you got out of law school, you passed the bar?
Oh yeah, I passed the bar before I graduated.
All right.
In those days, you could take it before you graduated, and I did. And I went to work for the district attorney in Travis County. Actually, I went to work for a large law firm in Houston. And I told them when I was hired I wasn't going to be there. I was trying to get into the DA's office. I wanted to try lawsuits. I wasn't interested in being in a pool.
You didn't want to be a rug lawyer?
I didn't want to be anything except a trial lawyer. And so about 3 weeks after I was there, they called from Travis County and said that they had a job for me, and I left and went there. Stayed there for 5 years.
So you're in the district attorney's office in Travis County for 5 years.
Right.
As a prosecutor,
Yeah.
that 5-year period of time, share with us your most memorable moment that you would want to pass on.
As a prosecutor?
As a prosecutor.
Well, I had the opportunity to work for one of the best prosecutors I've ever known in 50 years of practice, and Les Proctor. And he's a member of our Hall of Fame, TCDLA Hall of Fame. And he was an extremely ethical, very honest guy, and he demanded that of his people. There were only 5 of us, 5 assistant DAs in Travis County at that time. And as you know, the state crimes venue is in Travis County for all of that biggie stuff. We had the veterans land scandal cases and legislative bribery and insurance frauds and all kinds of things that we were involved in, and all street crimes too. But it was a great experience because I had great teachers. Proctor was great. Bob Smith, who was first assistant, was magnificent. And when I became first assistant over there, we had some outstanding young lawyers who were assistant DAs. And I think that the Proctor tradition, I later practiced law with Les.
So Les was your mentor, for lack of a better term.
Yes, absolutely. Yeah. I learned more from him than I could have learned any other place for 20 years. He was great.
That first 5-year period of time at the DA's office, is there one case in particular that stands out in your mind that you want to share with us as the most influential on your days as a prosecutor?
I probably tried about 200. As a matter of fact, I think about 200. When I ran for political office, I had to find out how many I'd tried as a prosecutor. About 200 jury cases. And a lot of them were insanity cases, you know, and it didn't take hardly any time. But at any rate, I lost 3 jury cases as a prosecutor. And I took the verdicts and I framed them and put them up on my wall. And every one of them taught me a lesson. And the first one was a theft that was habitual. And in those days, driving without owner's consent was not a lesser included offense. It was a misdemeanor, and you couldn't even put it in the indictment under the law at that time. And Jack Gary was representing the defendant, and the defendant was on parole, and he was a 2-time loser. And I thought, why in the devil is he pleading this guy not guilty in front of a jury? And of course, he blinded the panel on the prior convictions. They would come in. There wasn't a bifurcation at that time. And the kid got up and testified, that the defendant, that he didn't intend to steal the car, which of course nullified the offense if the jury believed him. But he said his parole officer had called him and told him to get up there fast. And so he found this car and he just got in it. And he said, unfortunately, he wrapped the car around a telephone pole, but he was on his way to see the parole officer. And the car was in the vicinity of where the parole office was. That's a bunch of malarkey. And, you know, I went after him. And finally, the jury got the case. And Gary and I went downstairs to get a cup of coffee. And 10 minutes later, the bailiff came in and said, the jury's got a verdict. And we ran upstairs, and I said, Jack, don't let this, you know, this was our first case, my first jury case and his first jury case. I said, this happens, don't, you know, 10 minutes is not, don't worry about it. Well, the jury came in with a not guilty, you know. I was really embarrassed by that, but I learned a lot of lessons from that. That is, don't overestimate yourself or your case. That's the most memorable thing in my prosecution days.
Okay. So in what was it? 5 years later, you decide that you're going to leave the DA's office.
Yeah.
And where'd you go?
Attorney General's office. I took over as chief of the law enforcement division. That's where I met Roy Barrera. We were investigating Charlie Leak down in San Antonio for fraud, actually for bribery. He was totally innocent, but we had a great investigation. And Roy represented either Wexler or Leak, I'm not sure which, along with Freddie Savannah.
Now, while you were at the Attorney General's office, weren't you involved in the Billy Saul Estes slant hole drilling cases?
When I left the Attorney General's office, R.B. McGowan was the prosecutor out in Pecos, and he had very little, you know, there's hardly any crime in Pecos. He had very little knowledge about the practice of criminal law. And he called the Attorney General for help with Will Wilson. I had just left, and Will had nobody to send out there, so he called me, and I was appointed a special assistant AG to go out there. The indictment looked like something that a garbage man would draw, you know, and it was terrible. And Judge Starley, the Kofers were representing Billy Saul, and Judge Starley granted a continuance denying a change of venue motion. We got a new indictment, and it was transferred on the court's own motion out to Smith County in Tyler.
What happened to that case?
Well, he was convicted. It was a simple case, but there were coaxial cables all over the place, you know, television rearing its ugly head all over the courtroom during the pre-trials. When it came time for the trial, Starley had cleaned it up considerably. I mean, you couldn't see the cameras, and it was much better. But the Supreme Court ultimately reversed the conviction on the issue of cameras in the courtroom, and really extreme pretrial publicity. It was a seminal case for cameras. The Shepard case was the seminal case for pretrial publicity.
You think those rulings would be the same today with our current court and our current emphasis on media?
No, I don't think. Well, yeah, I have to say this. I was really a coward in that case because, and it's one of the big things that I regret not doing. The Kofers had motioned to get the cameras out, and Judge Duggan had a son who was engaged in journalism at that time, and I think he was kind of swayed by that. Felt like he was on the cutting edge of something, in fairness to him. But the motion, and he said, I'd like to know what the Attorney General's office thinks of this, right in open court, you know. And the judge said, yes, what's your feeling about it? And I said, well, whatever the court wants. That's a terrible thing to say. I should have joined Kosel right then and said, get rid of these cameras.
You think people talk differently, behave differently, act differently in front of the camera?
Absolutely.
So we can discount everything you're saying today?
I would say I still keep them out. When I'm sitting as a judge, I won't let them in the courtroom. And it's created a little problem for me up in Travis County. Some of the judges feel pretty strongly about allowing it, but I'm still of the impression that cameras have a great effect upon the witnesses, the jurors, and the lawyers. I may be in a minority on that, but I don't think so. I think a lot of judges feel the same way I do.
So you spent 3 years at the Attorney General's office and then came back at Will Wilson's request to handle Estes. Why did you leave the AG's office?
Well, I was bored stiff. I mean, they had me closing body houses around the state, you know. And
is that body as in B-A-W?
That's right.
Okay.
Not B-O-D, but
Thank
B-A-W.
you.
And investigating district attorneys, but I wasn't trying cases. I mean, these things are long-lasting, you know. And in the DA's office, we were in trial every week. I mean, there were only 5 of us. There were 1,000 indictments a year. I mean, we had to be ready. We worked late hours, and just like you do now. I mean, it was a difficult, hard time, but a learning experience.
You enjoyed it, didn't you?
I really did.
You liked the courtroom, didn't you?
Oh, absolutely. I wouldn't be a lawyer if I weren't in the courtroom.
Okay.
I know there are people bent in the other direction.
So what did you do? Hang out a shingle on your own or go into partnership with somebody?
Well, no. Les and I ran for political office. I ran for county attorney of Travis County, and he ran for attorney general.
What happened?
We both were defeated. And he was defeated in the primary, and I was defeated in the runoff. And together we opened up an office in Proctor, Maloney, and Fullerton. Fullerton, who later became assistant dean and then dean of the law school up in Lubbock, was our law partner.
So that would have been what year? Just give us a frame.
1963, I believe. 63.
So from 1963 until when you went on the Court of Criminal Appeals, you were a criminal defense attorney.
That's right, yeah.
And you took the bench in what year again?
1990.
It's a long time, Frank.
Yeah, it was, but I enjoyed every minute of it. I can't think of right now of wanting to have done anything else but defend cases.
Let's talk a little bit about TCDLA and some of the folks that were involved with you, because you were the first president. Yes. You were numero uno. Yes. Always will be. And we've heard stories.
Yeah, well, terrific stories.
Well, and there was
Did
a different.
Did I ever tell you how I was chosen?
I was going to ask you that, because I've heard that, but I've heard it in 2 different veins. One time when there was no alcohol involved, and one time when there was alcohol involved. So let's hear the true story today.
Well, there wasn't alcohol involved in it, I have to tell you that. I mean, there was later on, but never at that selection. 2 great lawyers, Phil Burleson up in Dallas and Tony Frullo in Houston, both had an idea that it was time for an association of criminal defense lawyers. We had the criminal justice section in the state bar, prosecutors and defense, but they had their own group, the prosecutors did. The judges had their own group. It was time. And Dallas, the bar convention met, and Tony was really moving with pamphlets and everything else. And those 2 were friends, but they were also competitors, and both wanted to be president of this new group. They called a group of us together, and we met, and each one of them said, well, I want to be president. And Joe Goodwin was there, and Charlie McDonald, Emmett Colvin, and Doherty up there in Dallas, and I think we had some of the top lawyers in the state in that meeting, and they all agreed that there should be an association. There was no question about that. But the question was, who was going to be president? And so there were about 70 of us met, I think, the top of one of the hotels at the Petroleum Club there. Haynes was there in his usual great manner. And we were talking about what this association should do, you know. And finally, Freelo and Burleson and their backers, people from Dallas backing Burleson, people from Houston backing Freelo, they realized they weren't going to be able to get this thing done. And so they looked around and picked the most innocuous person they could find to be president, and that was me. And I stood up to give a speech, and everybody left. Nobody wanted to hear my speech. I was just appointed. Well, at that time, I was defending the Speaker of the House. I was defending a state senator, Jim Bates, down, and I mean, I was overwhelmed, and I really didn't want it. And Emmett looked at me and he said, "Oh, you have to take it."
You're speaking of Emmett Colvin.
Emmett Colvin. I said, "Emmett, why don't you take it?" I mean, it's in Dallas. He said, "Burleson wouldn't let me take it." So, all right. Well, the first thing I did was, I said, "We're going to have an executive director." And I sent letters out to our prospective board. They elected the board up there too, people from all over the state. And I said, "Is there anybody here who doesn't want an executive director?" And I got one letter back saying, "We don't want one." And I'm not going to tell you who that was, but he was an outstanding, brilliant lawyer. And I said, "The hell with that, I'm appointing one." So it was. I got Bill Reed, who was a Harvard law graduate and who had worked with me on the penal code revision. I was teaching. Another thing, I was teaching law at the University of Texas Law School, and man, there was no way I was going to get anything done. Ultimately, Reed stepped in, and we rented an office over in the Brown Building and had a big state map. Sent letters out to all the judges in the state asking them to recommend the outstanding lawyers in their area, outstanding criminal lawyers. And we got a tremendous response. And then we wrote letters to those people. And you had to be recommended. I mean, there was no way you could get in unless a member signed an application. And we had some of the best lawyers in the state who were members. I think that first year over 200. And they were fantastic guys, and they paid $150 to get in, which paid Reed's salary and the office rent and got me off the hook.
Frank, let me interrupt you.
Yeah.
First, I got to ask you, who was the outstanding lawyer that didn't think this novice organization needed an executive director? We've got to know for posterity's sake.
Well, he was on the board of directors of the National Association at the same time. That association was a good old boy organization, and he believed that it should remain, that TCDLA should be that way too. And there was some good arguments for that, you know, just keep the elite. But there was also a feeling about education and getting a legislative block there where we could do something in the legislature. And that mandated more than just good old boy. And it was Charlie Tessman.
I knew it was Charlie. Okay. Frank, I've got to ask you, and the charter members, and those are the people that you've referred to, they're recognized in voice, and the names are too numerous to mention here today. All outstanding lawyers, no question about it. But from the historical perspective, do you remember how the bylaws, how the purpose of statement came about? That's a beautiful purpose, a statement of purpose.
I wrote it.
You wrote it.
Yeah,
that's
and that's why they made me president, because I recited it up at that meeting, and they said, "Boy, this guy really has some, you know." I don't think anybody knew me except my ex-teacher, my ex-student. But anyway,
being a little humble, Frank, and that's a strong point with you.
No, and then I put together the bylaws. Our first meeting was in Houston, and we submitted the bylaws to the board at that time, and changes were made, a lot of changes in the purpose and mission statement too. I can't take full credit for that, but the big thing was education, a union of the lawyers together, and helping them in the practice of law. Those were the principles. And we had some magnificent guys on that board. I mean, you know, in addition to Burleson and Freelo and Colvin, Percy was on it. Haynes would come in and out, Charlie McDonald, Ned Wade. I mean, there were a lot of outstanding people that really worked hard.
At the time of the formation of TCDLA, can you share with us youngsters, what the legal environment was like for the sole practitioner or even a small firm of criminal defense attorneys? Because, you know, unlike the civil types, we don't have large mega firms. But what was the atmosphere like practicing law?
It was magnificent. From 1961 on, things changed. As you remember, Mapp versus Ohio was decided, and Escobedo and Miranda and Messiah and all these great, Aguilar and Spinelli, all these great cases were coming up in the 60s that opened up a road, a network for lawyers to really get into the courtroom and exert pressures to force police activity into something beyond a college roar, and it worked. And so you had young lawyers who were educated in the field of law, and things kind of changed from the emphasis was on winning on facts, and now we had a method of winning on law, and so there were subtle and sometimes open changes in the law. So by the time the 70s started, by the time TCDLA was there, and that was another reason for its growth, because the prosecutors were trying to get legislation, you know, to cut back down on these great Supreme Court decisions. And they were getting very successful. People were upset with the 60s and early 70s, the drug situations, the crime rate was extremely high. And you had a lot of young lawyers saying, boy, I'm going to get involved in this, where before they didn't. Before you had bond runners and people who couldn't do anything else, you know, pleading people guilty at $10 a clip. But when the 60s came and the 70s, I mean, it changed the whole complexion. And you had a lot of arrests for people from very wealthy families. Drug usage was very high. There were riots, you know, and what have you. And so there was room for a good criminal bar, an educated bar. And I think TCDLA played a big part in getting that moving.
In fact, Judge, isn't it fair to say that you and other members of the original formation of TCDLA charter members were involved significantly in the formulation of the 74 Penal Code and all the revisions that had made to the prior law?
Yeah, the Dean Page Keaton at the law school was appointed by the State Bar to be chairman of the Penal Code Revision Committee. And I was teaching out there. At that time, there were 2 or 3 others that were, and we were made reporters. And as time went on, the meetings, the revision started, and we used the ALI Model Penal Code, as those states who had revised it, you know, Indiana and New York and California and Minnesota all had new penal codes, and they were all based on the ALI. So we worked very hard, and in 1971, it was presented to the legislature. And of course, it failed abysmally. I mean, the prosecutors were really upset with it. And the defense, I remember Warren Burnett was furious about it. He couldn't believe it. I think Warren probably did more for the defense bar in killing it than anybody else. But so the State Bar decided that it was going to add a lot of prosecutorial effort. The County and District Attorneys Association played a big part in revamping the 71 code, the Blue Book, so to speak. And we got what was euphemistically called the Yellow Book, which was kind of a prosecutorial effort. And that was presented to the legislature. Well, it was draconian. And so a lot of us spent a good number of hours up there, nights, in front of the House and the Senate jurisprudence committees, changing the thing till it got to something workable. And it did pass. 73, 74 became the law.
Of course, that's post-Furman too.
Yes, was post-Furman.
Just from, excuse me, go ahead.
Well, they went ahead, though, and drafted a death penalty section, which I didn't work on. I refused to work on it. I told them I was against it. I wasn't going to fool with it. And I remember Bob Maloney up in Dallas, who was very active in jurisprudence, criminal jurisprudence at that time, really wanted to do something. And he was highly critical of us for not getting active in it. But they did enact a method which is not too different from what we have today. As you know, the mitigation issue has been enlarged, but they did enact a method, and it became the law once the Supreme Court decided the death penalty was not a violation of the Eighth Amendment.
Judge, do you remember testifying in front of the legislature about how that original interim enactment of the death penalty bill before the 74 Penal Code was enacted was ultimately possibly subject to a declaration of unconstitutionality because it still afforded the prosecutors that unfettered discretion in the charging area?
That's right. Discretion was a big argument then. Too much discretion. Still is too much discretion. But I think with the new without parole law, that you're going to find a lot of juries going in that direction. And I noticed the Court of Criminal Appeals had to decide a case just the other day on what disqualified of an Ironman. When this guy said, well, if there's another way of making sure this guy won't kill again, I'm against the death penalty. They said that's a disqualification. So you'll have the state filing the intent to seek the death penalty just so they can get voir dire examination individually, and so they can use it to bounce people off. But you'll find juries coming out with no parole.
I want to switch gears a little bit. As a defense attorney in those early years and even subsequent years, I want to ask you about your most memorable moments with a few selected individuals. In part because this is an 80th birthday celebration, in part because other folks are going to be interviewed, and we're getting a little cross-pollination, so to speak. But with regard to Roy Barrera, for instance, I know you've known Roy since day one, for lack of a better term.
Yeah, really.
What's your most memorable moment with Roy or Mr. Nicholas, you know?
Well, Roy, my most memorable moment was when we were investigating Charlie Leak, and Roy was representing either Leak or Wexler, I'm not sure which, along with Freddie Saman. And Roy was obviously the mind in that proceeding, although Saman, you know, was bright, very bright. I don't think he's as bright as Anise, his brother, but he was extremely good. But I remember them embarrassing me up one side and down the other. I mean, he was an excellent lawyer. And as a matter of fact, what happened was Albert Wexler was indicted. We did not indict Leak. Roy ended up defending Wexler, and Wexler was convicted, but Roy got the case reversed up on appeal on the introduction of statements made by Wexler before grievance committee. Court of Criminal Appeals held they weren't voluntary. And the reason they weren't was that Leak told Wexler, you go on up there and tell the truth. Just go ahead. Wexler had said, I don't want to testify for you. You go on up there and testify. Well, he inculpated himself. They said that was inadmissible. Okay. That was one thing. Another, Roy became Secretary of State. We had an extradition matter. I thought we were going to lose it. But as you know, at that time and now, you go before the Secretary of State to stop the extradition. And we put on some pretty strong evidence, and you know, I felt Roy was going to. I said, well, he doesn't want to look like a defense lawyer. He's going to rule against me, but I'll be damned if he didn't rule for me. Stop the extradition, and rightly too.
Excellent. Richard Racehorse Haynes. I've got to ask you about your most memorable with Richard, and I think I know what it is, but why don't you share it with us?
Well, Richard and I were involved in the defense of Gus Mutcher up in Abilene, and we became very close friends at that time. And I mean, it was a joy to try a case with him because, I mean, he had such a great sense of humor, and he gave me some pretty good advice. One of the things he told me was to stop taking myself so seriously. And I never forgot that, although it was very difficult not to. And anyway, at the conclusion of that case, we flew into Lakeway on one of the airplanes that Mutcher had at his disposal and went for sailing on my boat for about 3 full days. And I don't think either one of us had a sober breath during that time. It was a wonderful sail, though.
Alrighty. Knox Jones, former president.
Oh, Knox was a darling man. When he was in law school, Bob Jones was working for us, and Knox and Bob were very close friends. And so Bob brought Knox down to have him work for us, and I used Knox in a couple of as an investigator, you know. Then when Oscar McGinnis was indicted down in the valley, Knox was local counsel, and he was just a great guy. He was another guy who had a great sense of humor. You know, both he and Haynes, you'd laugh every waking moment of the day you were with them. I mean, they were just terrific people.
Well, Knox's name is on a very prominent opinion out of the Fifth Circuit.
Oh, yeah.
And that's where I was going with that question.
Right. Well, that involved a situation where the Judge Conley down in Laredo had held Knox and 3 or 4 other lawyers in contempt for failing to give the name of who had hired them to represent known mules, in effect, in a narcotics case. They were representing these people who were indicted, and somebody else was paying the fee, and the grand jury wanted to know that. They were going to use that evidence as a link in a conspiracy charge to indict the man who was paying the fee. And Knox and Ramon Gosler and Tony Canales and went from the grand jury, and they refused to answer the question.
Asserting attorney-client privilege.
Asserting the attorney-client privilege. They also asserted the Fifth Amendment, which was not applicable, but they asserted primarily the attorney-client evidentiary privilege. U.S. attorney certified them into court, and Conley held them in contempt and ordered them jailed. And I remember we went in there to Conley's office, and I said, I want bond. I want these lawyers released on their own recognizance. He said, there's no way. I said, I would like to appeal right now to Joe Brown, who was then Chief Judge of the Fifth Circuit. And he got Brown on the phone, and you could hear Brown. Brown was screeching. He was so upset with Conley. I mean, man, you did what? He said. And finally, the case got up to the Fifth Circuit. It was expedited. I argued that I could tell that we had a favorable panel. And Judge Thornberry wrote the opinion, and it established the attorney-client evidentiary privilege as far as who paid legal fees, which was important. That case was subsequently qualified by several cases. Judge Reevely, I remember, wrote an opinion, which was a linkage case. It had to be the final link before it could be deemed protected.
That would be Pavlik, correct?
That's right, Pavlik.
Okay. All righty. Emmett Colvin, former president.
Well, we were like brothers. As a matter of fact, we were brothers. I mean, it was a love fest between us. We just had a tremendous respect for each other, and we thought, well, Emmett used to surprise me, though. Emmett could win a case by spending time preparing character witnesses. And I mean, I never understood. I said, Emmett, you're not spending enough time on this, on the facts of the main case. You know. And I remember we tried an antitrust case down here. It's a bid rigging case in federal court, and Emmett had prepared character witnesses, and he had actually the bishop in Dallas, Roman Catholic Church, testified for the defendants, and we had several Catholics on the jury. But we sandbagged the state. They weren't about to convict these people. No way with the bishop testifying. That was all Emmett called, and sure enough, not guilty on those guys.
Frank, there are rumors that have abounded for years that you and Mr. Colvin spent an evening singing "They're Rioting in Africa" in the back seat of Emmett's car as you were chauffeured around Dallas after a successful verdict. Is that story true?
I think you were part of that.
I'm going to plead the fifth on that.
Wasn't that the case involving Zimmerman up there, a lawyer that we represented who was found not guilty in a tax leverage?
It was a RICO case.
Yeah, it was a first RICO conspiracy case tried in Texas, and a lawyer up there, and I remember Sarah Hughes was the judge, and that was an enjoyable case. That really was. I'll never forget Emmett slapping that cane on the table when he was cross-examining some guy who was lying through his teeth.
He was a great believer, as you are, of humanity in the courtroom.
Oh, absolutely. He used to say, "I'm sorry you're not going to hear Frank Maloney in final argument." He told the jury that. He said, "But because I love to watch his lips."
That was Emmett.
That was Emmett. I mean, I was ready to fall out of the chair when he said that.
You tried cases with Warren Burnett, haven't you?
Yeah, oh, Warren was something else. Warren was the kind of guy who would get up at 5 o'clock in the morning just to read a Q&A and get ready for his cross-examination. He never thought he was prepared for anything, and he'd go in there and he would tear apart witnesses. But he sometimes had very little respect for the judge in the case. And I mean, we went in on a charge conference one time, and he let me handle that, but he was sitting next to me, and there was a charge we had prepared for Judge Sessions, and Warren knew that I was losing the argument, and Warren said, "Judge, this is covered by Stromberg versus Carlson. Absolute case." Well, nobody wanted to look like they didn't know what Stromberg versus Carlson was, that they didn't know what it was. I didn't know. Sessions said, "All right, I'll give you the charge." So we go outside, and I said, "Warren, what is Stromberg versus Carlson? I've never heard of it." "Well," he said, "that really is not a case at all." I said, "What?" He told the judge that. He said, "Well, Stromberg versus Carlson is the name of a manufacturing company for cabinets that manufactured cabinets for television, and it's not even a case. No, it's the name of a company, but it sounds good." Of course, he had a juror on that case that fell in love with him. I mean, she was absolute. She was insane. And Jerry Goldstein was representing a fellow named Hernandez down here. We were representing Dickey. And Jerry, the jury came in and convicted Jerry's client, but they hung on our client, and they hung because of this crazy woman who was madly in love with Warren Burnett. It's 11-1. I mean, she broke the finger of one of the jurors during deliberation. She was so intense about hanging that jury. They had to call EMS and everything else. Something else.
Frank, you mentioned earlier about Knox and I guess the Laredo Six and in grand jury proceedings, Knox Jones. Have you ever been held in contempt by a judge?
I never have, no.
How do you feel about that?
I've held some in contempt. I've done it. I held the district attorney in contempt down in Lockhart. I had granted a motion in limine on witnesses not testifying as to a prior statement. And the first witness out of the box, the police officer, get up there and in direct questioning by the district attorney, blurted out that the defendant had made an admission. I got the jury out of the room and told them I could do one of three things: grant a mistrial, hold you of ignore it or hold you in contempt. Now I'm going to leave it up to the defendant. The defendant said, well, we don't want a mistrial. And so I said, all right, you're in contempt. I'll decide your punishment after the trial. And that was it. The DA in contempt. And as it was, I only fined him $500.
Do you think the playing field is level between defense attorneys and prosecutors from the perspective of the typical district judge, whether it be state or federal, currently, as opposed to perhaps back when you started practicing? Do you feel there's been a change in the playing field?
Well, judges back when I first started were never defeated. I mean, you very seldom saw a judge defeated. He was there for life, even though he was an elected official, at least in the courts that I practiced in. And the federal system, of course, they're appointed. I think that we're getting much younger judges than we have. But that just may be my age. I mean, I go to judicial conferences, and I see a lot of young guys, some of whom were students of mine. I mean, I can't believe that they ever got to be judges. But anyway, that's a hard question, David. It really is. I don't know. I look at things now as changes in the bar. I see tremendous changes in the bar from the 70s. And again, one thing about being a judge, you don't have the emotional problems when you're sitting up there that a person who's down in the pit does. The guy who's litigating is worried about what this one's going to say or not say and what his witnesses are going to do. And I mean, he's filled with all kinds of anxieties. Judges sitting up there, and I think can objectively see more what's happening and why this guy is good and why. And I constantly feel like, why doesn't he ask that question? You know, why did he ask that? You know, and I want to hop in and ask the pointed questions. And of course I don't. Well, sometimes I do, but I don't know about the judges as far as them being better or worse or the younger.
Now, let me rephrase. How do you feel about the fact that judges in the state system are elected as opposed to being appointed? Do you feel that that's good, bad, indifferent?
I think it's good on elected on the local levels, up to a point. In other words, I would have them run against themselves. The Missouri system, a friend of mine is on the Supreme Court in Colorado. They have the Missouri system up there, and he goes through hell every time he's up for election. Because if you're bad, there's enough force to get out there and level in on you. And you could very well lose an election. And I think statistically, the Missouri system has shown that they have gotten rid of a lot of bad judges. But I think on the statewide and the intermediate appellate, they either ought not to be elected, probably appointed from past experience and excellent people. Of course, politics always is going to be involved in it, whether you're giving $100,000 to the governor or whether you're giving $10,000 to some local campaign. But it seems to me our appellate judges could be selected a little better than where they are, because people just don't know who these judges are. And they're voting out there blind. They're voting on party affiliation. So at the very least, you ought to take the parties out of it. And certainly on the top level, Court of Criminal Appeals, Supreme Court. Now, a lot of lawyers would disagree with that. I've never known a lawyer who didn't think that this judge was his great friend, or so, you know. That's most judges that I know try to do the right thing. Sometimes that's awfully hard, very hard sometimes, but they do.
Let's talk about judges making hard decisions. As a defense attorney, and this may be an unfair question, but as a defense attorney, what do you think? Tell us about the situation where you think you put a judge in the most difficult position
possible and how that judge reacted?
You want to think he's going to do the right thing. And I've seen a good number of judges do the right thing. I've also seen a lot who were politically influenced. I mean, and I feel upset because the system breaks down when that happened. When you decide a case, when you're result-oriented, or when you decide a case based upon politics of the thing, the system's broken.
Talk about the judges that you have had and developed either the closest relationship with or the most respect for during the time frame of before you took the bench at the Court of Criminal Appeals, because that has to have skewed your relationship a little bit. But as a defense attorney, you had a unique relationship with any number of different judges. Why don't you share a couple of those relationships with us?
Oh, I don't think I want to do that. I don't want to embarrass them. I've had a lot of good friends, but I've never had a judge decide something on the basis of friendship. At least if he has, I haven't known it. Most of the time, of course, I've lost. I mean, we're defense lawyers. We don't expect to win everything on the district or trial level. But I think I used to go to lunch with a federal judge, at least once a month. We'd get in there and argue all kinds of politics, and he was a big Republican and I was a Democrat. And I guess I appeared in front of him maybe, once a month or whatever.
Talking about Jim Nowen, aren't you?
Well, I don't want to mention his name. Ouch, you shouldn't have said that.
Well, they can edit it out, Frank.
Good, edit it out. But I'll tell you about him. I remember one time we had an 803. Was that the one where we had a couple of co-defendants testify in front of a grand jury, and they had exculpated our defendant, and we wanted to get that grand jury testimony in because they were going to take the stand and take the Fifth Amendment, and but we wanted there to put that in as original evidence, direct evidence. And I remember Len Centerode, who was the prosecutor at that time, told the judge, he said, if you do this, it'll be the first time in the history of jurisprudence it ever been done. And the judge looked at him and said, oh, that's intriguing, and then ruled against us.
Who's the best state court judge you think you've ever appeared before?
Jimmy Myers. And he was a civil judge primarily, but he was without a doubt the kind of judge that you'd want to be. I mean, he was very ethical and very realistic, but he ruled with the law. And I've seen him lace out a district attorney because the district attorney miscited a case, or didn't cite it, the case that I was in, and I had already excused my witnesses because the judge had ruled against me. The next morning I found the case and brought it in and put it on the bench, and he just went and hit the district attorney up one side and down the other. And for months after that refused to try cases for that district attorney. But he was an excellent judge, both civil and criminal.
Who do you think the best federal district judge you've ever appeared before was?
That's hard. I can't. Nowlin was very good, I thought. I thought that Judge Thornberry was pretty good. But, of course, he won a lot of cases in front of him. He was a great guy, too. Judge Rice was a stickler. We had well, that's another story. Judge Roberts was the most pragmatic judge I've ever seen. I mean, he was.
You're referring to Jack Roberts.
Jack Roberts, yeah. And I don't think I ever won a case in it. Yes, I did. I had a not guilty in a tax evasion case, and the co-defendant hired me to come in and try his case. And Jack put a lot of pressure on me to plead him guilty because he said, I'm going to tell you, you either plead this guy guilty, or if he's found guilty, he's going for a long time. This was before the sentencing guidelines. Jack had that way. His whole background was prosecutorial in that. But in many ways, he was very fair. Very fair.
Speaking of sentencing guidelines, a major change in the practice of federal criminal law.
Yeah.
Realizing that Booker has modified them somewhat since they first came in, How do you feel about that as a former prosecutor, defense attorney, and judge? How do you feel about the sentencing guidelines? I'd be interested in that.
Well, I worked for a good number of years on the proposal for Texas, and primarily because I'd been on the Criminal Justice Council, the ABA, and they were big on them. And I remember Judge Breyer, who's now on the Supreme Court, was on the Sentencing Commission that wrote a lot of those guidelines, and oddly enough, he was not as liberal-oriented as he is today. But I'm glad that Booker. I'm glad that you can have downward views now on them. They were very bad before. I mean, it's terrible to put somebody in the penitentiary who has no prior record and who has committed a technical offense simply because the guidelines say that. And I know Nowlin fought them. That was one good thing about Nowlin. He fought those guidelines from the beginning. He was reversed a lot of times by the Fifth Circuit. He really fought them. And then still, Apprendi has helped a lot. And I think there's still a need for a lot of modification. A lot of modification. The punishment ranges are too high, way too high for a lot of these. And we have more crimes today than we've ever had. I mean, every time you turn around, the legislature or the Congress is passing a new law. It's terrible. But these laws that are not prohibited in whatever it is.
Malum per se?
Malum per se, thank you. Time's going on. These crimes that are not malum per se ought to be lowered tremendously as far as the sentencing guidelines are concerned.
Okay. Let's talk about your stint on the Court of Criminal Appeals. And I want to ask you about the other judges. That'd be unfair. Some of them are still there. But you wrote a lot of very good opinions. I won't name them all, but of all the opinions that you wrote, what opinion were you either the most proud of or believe was the best opinion you wrote, if that's a fair question?
Well, I think all of them had some defect in them. I mean, there's no such thing as a perfect opinion. Gisa, I think, was probably one that I was very proud of. I worked on that almost a year. And now, of course, it's been overruled. And then Cluis, I think, giving the Courts of Appeals the right to conduct factual sufficiency in criminal cases. That was an extension, of course, of the affirmative defense factual sufficiency. Rusty Duncan, I think, wrote that. And those two particularly, I can think of a lot of others that are still the law, but they didn't have the effect that either Gisa or Cluis had. I'm surprised that the court reversed Gisa so easily after I get off of it, but I think they could have modified it a little, needed a little modification. Cluis is still standing.
Frank, you've taught thousands of lawyers through the years, whether from the standpoint of working with them our cases, being a teacher at UT. How important is the knowledge of the law to the practice of law today?
Absolutely mandatory. You've got to know it. I mean, there's so much. If you don't know it, you've got to at least be able to find it. And we've gone from books into computers now. I remember when I went on the court, I had to learn how to use a computer. It was still in the box when I got over there, and I went to schools and everything. It was a new world for me. But knowledge of the law is mandatory, I think. I don't see how anybody can defend anybody if they don't know the law. And certainly if they don't know the law of the case that they're defending. I mean, it doesn't take much to do some thorough research. A case ought to be prepared by knowledge of the indictment, knowledge of the evidence, and knowledge of how the court's going to instruct the jury. This requires some research. You ought to have your charge prepared before you even go into the courtroom.
What was the first thing you used to do when you would get a client who had been indicted? What was the first thing you'd do?
Look up the law. I mean, whether I knew it or not, I looked at the statute. I looked if he had already been indicted, at the indictment, the law of the indictment. Of course, after Studer, you had to, because if you don't make those objections, you're waiving. And now with the case law, they finally adopted the federal system where in sufficiency matters, you don't have to look at the charging instrument. You simply look at what the statute would allow, what the evidence is, and that's it, even though the jury had not been instructed properly on the law. It doesn't make any sense. There's got to be some symmetry in law. It's a magnificent animal if it's properly fed, and the unfortunate thing is today that we're overlooking a lot of things that we shouldn't be overlooking in evaluating cases. And I'm not talking about the lawyers as much as I am the courts.
Probably a totally unfair question, but if you had to pick one case that is your favorite case, whether it was as a prosecutor, a defense attorney, or a judge, what's your favorite case that you've been involved in?
Well, anyone that I've gotten an acquittal on as a defense lawyer. And of course, even after 50 years of 30 years as a defense lawyer, there weren't that many acquittals. And I don't think we should really think we're going to get a lot of acquittals. I mean, it's wonderful to get them, but in 50 years, if you've had 10 acquittals, you've done pretty well.
Now, you've had more than 10 acquittals,
Yeah.
Frank.
But,
So.
Well, I don't think I ever lost a DWI case when I was. But the fact of the matter is that if you go into the courtroom and you represent your client properly, legally, and ethically, you're doing your job. Now, I can't tell you what the best one was. I mean, the ones that stand in my mind most are the ones that I lost as a prosecutor, and the ones that I got clobbered as a defense lawyer.
From those losses that we learned the most, would you agree?
Absolutely. Absolutely. You're not going to. I mean, the wins are great. Of course, they're great. They're wonderful. But the losses are the ones that stick in your mind, the regrets.
If you were to be able to pass on one and only one thing to the up-and-coming lawyers within TCDLA and or potentially coming into TCDLA in the next few years, what would you teach them? What lesson would you impart to them? Because unfortunately we can't give everybody a brain transfusion from Maloney as much as I wish we could.
Well,
You have 50 years of experience. Give us a couple of them.
lawyers, what you'd have.
Well, I know that they're at least riding in Africa. But,
Yeah, that's right. That was a great song.
yes, it was.
The Kingston Trio.
But what do you want to leave us? What lesson would you teach the young lawyers coming up?
I had a lot of great lawyers working for me as a lawyer in my law firm. Yourself, and David Reynolds, and Barry Gold. Linda Wright. These people were exceptional and have all become successful, outstanding. And I think the one thing, if I looked at, in addition to the knowledge of the law, the one thing that I think made them outstanding was credibility. And if I had to tell a lawyer today, a young lawyer, don't lose your credibility. That can mean the loss or the win of any case you're in. And once you lose it, it's difficult to get it back. But if you go into a courtroom and you're known as a credible lawyer, a fellow that doesn't mislead the courts, doesn't put on perjured testimony, doesn't do everything that is pushing the envelope on ethics, but primarily you can believe him. When he tells you something, it's there. That's what you want to maintain. That's what every lawyer. And unfortunately, the criminal law, the general public has a great feeling that criminal lawyers aren't credible. Where this comes from, I have no idea. But it's time that it ought to be thrown out. That view ought to be gotten rid of. So that's what credibility.
Right.
is Mr. Roy Barrera, who just came in,
Hello, Roy.
the Secretary of State.
Frank, firstly, we want to thank you for sharing an hour's worth of your thoughts with us. But I'm going to give you, I've asked a lot of questions, I've given you some open-ended questions, but after the lesson you just taught us, what you wanted to share with us, what haven't I asked you that I should have asked you to allow you to say to all these lawyers what you want to say?
I can't believe you haven't. I don't think I've spoken this much in the last 50 years.
I don't believe that.
Thank you.
Roy Barrera.
Thank you, Judge.
Thank you. It's been a pleasure. It really has.
How in the world? No, hell, by the time, anybody woke up, it was on a Saturday night. Saturday morning.
You said, don't tell anybody I told you.
No, I didn't even tell him that. Hell, I was standing up to it. I figured, hell, what can they do? Find me? So, and the funny thing is, this parking lot that's always been there belongs to the church, and the building that we knocked down was in this location. So I came, and I never heard a bigger racket at 2 o'clock in the morning that damn bulldozer was doing. It sounded like everybody in San Antonio could hear it. Like, God damn, it was loud.
And mass was going on.
Yeah, so, no, it was too early. So up drives a police officer. Said, oh, hell. So he drives up, and he said, what's going on? And I said, officer, we're knocking this building down. I said, we're doing it early in the morning so we don't have to worry about traffic. We didn't have barricades, nothing, just a damn bulldozer pushing that.
No permit.
No permit pushing that building in. And when I spoke, all of a sudden the officer said, Roy, is that you? And I looked under there, and sure enough, it was a cop that I knew. And I said, yes. He said, well, I'll see you. And he got the hell out of there. He wanted nothing to do with it.
That's wonderful.
Yeah, we tore it down and built this little building in its place. And
it's a nice building. Really.
Yeah, we've been here since '72. This used to be, I had shelving, right in here we had these library extensions coming out. Yeah. And we had these lights and little desks and all that. But, as time went on, we needed more space, and Roy came in, so we gave him that part of the library and made it a office for him, and we decided, hell, we couldn't afford the luxury of these stand-up. Besides that, with the advent of computers, who needs books?
And you still have a lot of them, though.
Oh, yeah. I still look into them. I can't get used to punching buttons and having somebody else.
This guy lives on a computer.
Does he?
He's got 3 in his office.
Is that right?
He goes in there at 6 in the morning, and at 11 at night he's still on it.
God damn. Well,
they don't use books anymore.
Well, that's a fact. That's a fact. And my son has been urging me to get rid of these books. I said, no. I'm not going yet. If and when I leave, I said, then y'all can do whatever you want.
Southwestern border.
That is true.
Yeah.
I was commenting that I hope nobody really looked at the books behind the speakers, because they're going to say, nobody's used that set of books in 20 years. Texas form, proof of facts.
Yeah, proof of facts.
How about Texas jurisprudence?
Oh, yeah. It's probably like jurisprudence first, and we're like on jurisprudence 10.
How did that happen?
We're slightly.
I'll tell you how it happened, Judge. They put us out of library money business with what it costs to update and keep all these books up to date.
Yeah.
It's horrendous.
Yeah. Do you know, you remember Borger, who used to be the book salesman up there in Austinville West?
Mm-hmm.
You know that when they bought him out, how much money he got?
More than I've ever made in my life.
I mean, well over $10 million.
Yeah.
Is that right?
Yeah.
All the residuals.
And he was on residuals. He was just a salesman, and I used to feel sorry for the guy coming around. But we better get over there, man. We gotta.
You're going back to the.
We're gonna go see Scrappy Holmes.
Yeah. Well, I intended to get back over there too. If you walking, or how you doing? Because I can have my daughter take us back over there. I intended to go back over there.
Did you?
Yeah.
Okay, the next one's at what, 1?
1:30.
1:30. Okay, well, I need to get over there myself. And
I wanted to go to that presentation
Yeah,
of
that's
him
what we're going.
and